over the last 3-4 years, this stuff hasn't been around that long, suddenly I found myself entrenched in issues relating to online XYZ. And today's topic, as advertised, is all about online copyright issues. So what I'm going to try to cover, and I don't take credit, this is a fabulous presentation, but I did not write it, so if I look like I'm stumbling on it, you can blame Josh and Rashawn. And I'll call on them as we go through it. But at any rate, the overview of copyright law. What is it? Some of you may have an idea. Some of you may be confusing it with other areas of intellectual property like trademark and patents. And when do you use the word copyright versus a trademark or a patent? And then go into some of these social media sites. The most popular, of course, are Facebook and Twitter, and kind of analyze the terms of use as it applies to copyright law. And as we know, Facebook, for example, changes its policies as it pleases every so often, and there's a lot of watchdog groups that kind of keep them in check as well. But as of now, we can kind of cover broadly issues like, does Twitter, Facebook own my content? Can I sue Facebook or Twitter for someone else's infringement of my content? What happens? Who owns all the stuff that goes out on the internet? We're going to talk about the DMCA, the Digital Millennium Copyright Act, which is a safe harbor provision, and I'll go into it in more detail, providing Facebooks and Twitters with liability protection from claims of copyright infringement. And a lot of you asked about posting and sharing news stories. I think we have our marketers in the house. Hey, introduce yourself, Lisa.
Sorry, hi, Lisa Gissel, Eastman Design.
I think we have some extra chairs here, and Michelle can grab some more from back there as well. So come on in and get some food. Before I start, has everyone gotten pizza if they want pizza? If not, please, I'll take a 2-minute break. Go get it, because it's going to get cold and gross, and that would be sad. All right, so I will start. We all know what we're going to cover. That's everything. Let's start with the basics. Dave, you have a seat? All right, so how many of you know what a copyright is inherently? Okay, so does anyone need a kind of a refresher? I'll give you a 2-3 slide refresher on what copyright law is and what it isn't. So at its core, copyright law is a set of exclusive rights given to an original author to regulate the use of a particular expression of ideas. That's the legal jargon. What it is, it's your photos. It's the rights you get to own your photos, your music, your written content, anything that you've created. What it's not is it's not a logo, it's not a source identifier, and that's what trademark law protects. Trademark law protects the brand name of something. So, give me a business name, Very Chill. Very Chill is the trademark, perhaps the art or the website or the content or the music that Very Chill uses, that would be subject to a copyright. So, brand, content, that's the distinction between a trademark and a copyright. Patent, sometimes people use interchangeably. A patent only relates to the idea for doing something. So an invention, the way a business method, the way a device works, you know, kind of going through the patenting process, right? So those 3 areas of law broadly are referred to as intellectual property law. So when you hear about protecting intellectual property, it's covering copyrights, trademarks, patents, etc. Trade secrets, it's like the brother of these 3. And it talks about things that are proprietary but aren't necessarily protected by copyrights, trademarks, or patents. When can you get a copyright? Technically, you own something as soon as you create it and you fix it into what's called a tangible medium. Me talking right now, is that copyrightable?
Words, no. Presentation, yes?
Yes. Presentation, yes. But what about the video?
Yeah.
Yes. Who owns the video? Me or the person taking the video?
The person taking it.
The person taking the video. I'm doing all the work here. I'm talking, I'm up here, but at the end of the day, the person who took the video can go off and do whatever they want with me talking. So that's something to think about. And we have a lot of lawsuits in the house about, well, I gave the idea and I hired this person to create it and I was telling them what to do. But if they're not the ones videotaping or writing or creating, then they're not the owners. So I will touch on ownership as we go through, but it's very important to understand ownership as it relates to copyright law. Again, I may be all over the place, so stop me if I'm not clear. All right. At its core, this is what you are licensing or requesting permission to use if you're or giving or granting permission to use if you're a copyright owner. You get the right to make copies of your work, the right to prepare derivative works, which means if I write a poem and then I want to write a full book about, based on the poem, or if I have a book and I want to make a movie based off the book, the movie is the derivative of that book. So I am the only one who has the right to make that movie. That's why you buy like story rights or option, you've heard about the rights to a movie, the rights to whatever. That's because you want to have the right to create that derivative work. You have the right to distribute copies, the right to perform the work, and the right to display the work. So this is the crux of everything that goes on online. These are the rights that Facebook, YouTube, any social media site, any site is requesting a license or permission to use. And on the other side, if you're the content owner, you're the business that has web content or photos or images, these are the rights that you are protecting and may selectively decide to allow others to use. Okay. They are your rights. They're your rights automatically, but they're worthless if you want to sue anyone for it. This is little known fact. So copyright law, yes, putting a little circle and, putting copyright notice 2011, that just puts people on notice that it's your work. But if someone rips you off or infringes on your content, you will not be able to sue them or get any money for that infringement unless you file a copyright registration. Okay. Yes?
Just a quick point of clarification. So, as I understand it, when I upload a video onto Facebook or YouTube, the second I upload that, I give up my right to that material because now they own it as the host, correct?
Not correct.
Not correct?
Not
okay,
correct.
That's good news.
That goes to this question. Does Twitter, Facebook own my content? And so, if you want to talk about it now, we can talk about it now. But let me just finish what actually, I'll talk about it. Remind me if I don't cover it, but I will cover it. Yeah.
No, just to clarify, so I was under the impression that like the common law rights gave you the right to sue but not get fees. You're saying you actually don't have a right to a lawsuit if you haven't registered?
It's now that was like 30 years ago.
Okay. I'm an older guy.
No, right. So it's purely governed by federal statute now. And you can only bring copyright claims under federal court. And in order to bring the claim, lawyers, you need a registration.
So you'd actually be subject like a motion to dismiss if you tried to do it without registration.
And that's what the first time now many of you will not get registration for your website content. And someone rips off your content. And then you call me and you're like, God damn it, what do I do? So you can then file a registration and file suit, but what you lose are these lovely statutory damages and attorney's fees. So if you file your registration more than 3 months after you put the content out to the public, or if you file the registration after the infringement has taken place, you can sue, and you can sue for maybe actual damages or lost profits that the other person made, it goes both ways. So the profits they made or your damages. But you will not get to take advantage of what are called statutory damages. The Copyright Act is one of the few in our American legal system that gives attorney's fees to the person who brings the suit and wins. So if I'm a copyright owner and I sue because I've registered in time, the person who loses could have to pay my lawyers, fees. And the minimum amount of damages per infringement is $750 up to $150,000. Which was when, if you remember the recording industry cases, when they were suing for downloading music, and you heard about these big judgments, it's because if I download 10 songs, 10 times $150,000 can be a lot of money, right? Yeah.
If you wait till, say, a year after you go online, but sue immediately upon the infringement, can you get the fees?
You cannot get statutory damages. You can get fees, but practically, let's give it in the context. I have pictures on my website. Maybe they're not really that valuable, but they're valuable to me, or I have catalog photos, or whatever. I have just a picture of myself on the website, and someone takes it and puts it on their site. I can sue for actual damages, but what are my actual damages? I'm going to have to pay someone to identify what the cost to me of that infringement was. If I have registered in time, I just go and sue and scare that person with the statutory damages, minimum of $750 up to $150,000. So registration is really important. Everyone knows what copyright law is, but everyone has this false sense of security because they think that that Circle C that they slapped on is enough to give them protection in their work.
And that's within how many months?
3 months. So another question I always
From
get
the time
is
you published your
from the
website.
time you published. What's the question?
I was going to ask the same thing you just said. Was
From
it
the
from
time you've
creation or publication?
Right now, if you've unpublished works, then again, it's not published, so people don't know. But it has to be before infringement. So you can't wait afterwards to get these statutory damages. Yes.
Is every change that you make to the website a new publication that starts your 3-month clock?
The new stuff would not be protected. Well, yes and no. You have the right to sue for someone making derivative work. So if I own the book and you made a movie and you didn't ask for permission, the registration for the book would be enough for you to get the damages that you're seeking.
If I have a website
Yes.
and it's not music, it's just narrative,
Yes.
then I make changes to it.
Yes. You are the owner of the changes, the derivatives. So technically,
So the derivatives don't relate back. I can't change one page and bring back in my original 30 pages. My original 30 pages that I didn't register after 3 months, I can't go back and save it. Or I can't.
yeah, you can. This is getting a little too. We have a lot more stuff to cover, but we can. But the end of the story, the takeaway, is that derivatives are owned by you, so you can sue if someone copies even part of it. If you have if you don't even necessarily need to copyright the final product, it's just extra protection. With things like websites that are constantly changing, then you want to file a new one every 3 months to cover the new content. That's why new media can be complicated. Now, you can try to do the catch-all because you can say the new content was a derivative of the old content, but if there are clearly different articles and they were published in different dates, then they would need a new registration. Does that answer the question? Right, that's copyright law in like 30 seconds. Obviously, it's a huge body of law. I can't go into everything, but before we go to fair use, the question about who owns it, does Facebook own it, or not? So you are all the owners of the content that you create. When you upload it to social media sites, it's very important that you read the terms of those sites, because one site may try to own everything, but the majority of these sites, including Facebook and Twitter, what they ask for is a broad license to use your content however they may choose. What's the distinction? So if we go back to this, Facebook, by its very nature, is displaying your work once you upload it. And that's technically an infringement, because you own your work and you are the only person who can display the work. Now, you're using their site to display your work. Now, Facebook, they want to make absolutely positively sure that you're not going to sue them for copyright infringement by doing any of these things. Inherent in the site is people are making copies between profiles, maybe someone's making a derivative through some sort of application, whatever. So to cover their own butts, they get a very broad license to use your content. A license is different from an assignment because they don't own it. They're renting your house. When they're done renting it, and in fact, if you felt like it, you can have 20 people renting your house at the same time. The other renter may not like it, they may not rent from you, but you could say 20 people can live in my house right now if I want them to. Assignment says, I'm selling you my house. If I have a photo, and if Facebook said in the words, read the terms of use, if the terms say you are assigning to me the rights to your content, they're taking from you and now own the content. So if you look at terms, most of the time they're going to say a non-exclusive, broad, and I had it in the presentation, but I think I took it out, but we can pull it up at the end. But and the keywords are exclusive versus non-exclusive. What does exclusive versus non-exclusive mean? Exclusive means they're the only one who can rent your house for a year. Non-exclusive means we're one of the 20 renters in your house. Perpetual means forever. The rental term is I can squat in your house as long as I want, as long as I pay rent. Or not squat, but I can live there as long as I pay rent. At any rate, so it all goes back to these set of rights. Now, as a right owner, I might say, you are allowed to make copies of my work. I'm giving you a limited license to just do that. But I'm not letting you do this other stuff. So you can parcel these out. Or I'm allowing you to do all of these, but you can only do it for 3 months. After that, your license to use my work stops. And that's what lawyers do, really. They're negotiating these set of rights in the context in which you're allowing people to use them and not use them. All right, so we talked about damages. Now, fair use is something that's going to interplay itself, or that's the word. It's going to be a defense used often, especially in the context of the internet. I was sharing the story, that's fair use, or maybe that's not technical infringement of those rights. Or my relation of this news article, even though I used the whole thing, was for a greater purpose. So even though it's technically infringement, I'm okay. This is the fair use. So it's the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching. Scholarship or research is not an infringement of copyright. Here's the problem. It's so fact specific. I can be a nonprofit organization using someone else's copyrighted work, and the mere fact that I'm a nonprofit organization does not mean I'm entitled to the fair use defense. The question that the court is going to ask is, what was the purpose and character of the use? Is it commercial or nonprofit? I can even have a commercial use that's fair use. If I have t-shirts with a political logo on it, and I'm selling the t-shirts with that political logo that has a picture of Obama or whatever, a photo on it, even though I'm making money, that could be fair use because I'm making social commentary. I could be a nonprofit organization teaching materials in class, and I have to pay for that. That would be infringement. How many of you all went to college or something, right? You had to buy your books, didn't you? You were using it for an educational purpose. You were reading the books, but you certainly had to buy that, and those book publishers have rights to the content. So don't feel a false sense of security because you're not making money off the use, or because you're a nonprofit organization. What's the nature of the copyrighted work? What's the amount of the work used? And the main real focus is going to be, what's the effect on the value of the work or use by the underlying copyright owner? So, for example, parodies often fall under the fair use exception. If I have a silly song, and if there's a famous song and someone parodies that song, obviously the person listening to the parody knows it's a joke. And if they wanted the real song, there are different markets, there's different channels of trade. I'm not confusing the first person with the second one. They're not making any less sale, arguably, again. The main song owners aren't making less sales because of the parody. They're serving two different functions. Even if it has an effect on the value of the work, maybe that First Amendment right to make that parody or make the social commentary outweighs my rights as a copyright owner. So this is, again, go to a lawyer. What's my exposure to liability for the use of this content? Will I have a viable fair use defense if I get sued? What I'm usually going to tell you is you don't want to defend on this, because if you're getting to the fair use defense, it's going to be a lot of time and money in lawsuits trying to defend your position. Yeah.
Does attribution affect this at all, if you attribute it to the original?
It's factual consideration. Attribution meaning you give credit. I used someone else's stuff, but I gave them credit. Not necessarily enough. Maybe, but maybe not. Again, it's a fact-based analysis, and it depends on every situation. All right, so social media. Now, this kind of goes, yes?
Oh, sorry, I had a question about fair use. We send out like a news clip summary every morning with relevant news clips, and sometimes if there's articles that are behind like a member login, we'll just take all the text of the article and send it out. Normally we link to the articles on other pages. We say who the article's by, but would that be fair use since it's...
Probably not. But again, it depends. I think we even did this for you guys. But yeah, so technically, no. There's a member login. You're bypassing that content access. So you're trying to work around it. And Michonne, I think, has some cases at the end with Right Haven lawsuits. If you've heard of the Right Haven lawsuits, maybe not. But we'll go through that. Have you heard of patent trolls? No, this is all lawyer bland. But now there's copyright trolls, which essentially, and I'm going out of order, so sorry if I repeat myself, but copyright trolls are people who buy the rights to someone else's copyright. Let's say I write a news story, and Beverly comes and says, will you assign me the rights to your news story? What's the difference between assigning and licensing? Right. Will you sell me your story? I say, okay. I sell it, and that's it. Not mine anymore. She then goes out and hires a company to locate anyone and everyone who's using my news article in some capacity, start suing them. And that's fair use is what we'll talk about again. Right? Okay. Facebook terms of use, protecting other people's rights. So Facebook, all these sites are going to have some codes of conduct. You want to use Facebook, and I'm one of those people who's like, you use the site, too bad. Like, your privacy is in danger, or your content got stolen. I mean, you signed up for it when you started using the webpage. If you don't like it, don't get on Facebook. Don't get on Twitter. Now, on the other hand, if Facebook pretends or promises to do something, then they have to uphold their contractual duty to you through the terms of use. As it relates to just copyright law, now that was kind of a broader policy or whatever, is Facebook good or bad? With respect to copyrights, they tell you that they reserve the right to bounce your content or bounce you off Facebook if you do anything that's not kosher. Not kosher is defined as you don't take other people's stuff and post it. You know, usually they have a little copyright notice. If you notice when you upload pictures, I think it does say that. Yeah, like you promise that this is your content. Most of you don't even think about it because you're uploading your own photos, but you haven't taken like a picture from AP of Angelina Jolie and posted it. People do all the time, but technically you're not supposed to. We can remove any content or information you post on Facebook if we believe that it violates this statement. You will not post content or take any action on Facebook that infringes or violates someone else's rights or otherwise violates the law. And if you repeatedly infringe other people's intellectual property rights, what's intellectual property? I teach a law school class, so I'm making, yes, I'm in that mode right now. We will disable your account when appropriate. Okay? Same thing with YouTube. You are solely responsible for your own content and the consequences of submitting and publishing your content on the surface. You affirm, represent, and warrant that you own or have the necessary licenses, rights, consents, and permissions to publish content that you submit. You further agree that content you submit to the service does not contain third-party copyrighted material, that means somebody else's stuff, or material that is subject to other third-party proprietary rights, unless you have permission. So it's the same thing repeated in more legal jargon. Okay. Flickr. You users agree not to upload, post, email, transmit, or otherwise make available any content that, again, infringes any patent, trademark, trade secret, copyright, or other proprietary rights of any party. You guys get the drift? Okay. Same thing with Twitter. And now with Twitter, notice, we will respond to notices of alleged copyright infringement that comply with applicable law and are properly provided to us. What is that talking about?
That you registered it.
Kind of. All of these sites don't want to get sued for copyright infringement. If I post a picture of Angelina Jolie and Angelina Jolie gets angry, can they sue Facebook? Can they sue Twitter? David signed. Well, is that are you
will.
Okay. Can they successfully? Everyone can sue everyone, so that was a trick question. Yes, everyone can sue, but can they successfully sue Facebook or Twitter or any of these sites? Why not?
Because of this contract, they need to go after the user.
Yes, kind of. Good half answer. Grant?
The other part is they have to comply if they've received a takedown notice.
Well, let's back up. Grant talked about a takedown notice. All of these social media sites get the benefit of the Digital Millennium Copyright Act. That means there's a law out there that provides what's called a safe harbor to forum providers. So if I'm only providing the forum for you to upload your content, this could be a Flickr, a Facebook, a Twitter, a blog. You guys may have blogs, and people upload content to your blogs. Then you, the forum provider, you being Facebook, your blog, whatever, will not be on the hook for any copyright infringement so long as you, the blog writer, the Facebook, whatever, the YouTubes, follow the registration procedure with the Copyright Office. You designate a registered agent that will handle copyright disputes that come to your forum, that come to your site. So I send to Facebook or YouTube, and I have an example. Let's see. Okay, so again, so if Facebook, for example, follows the takedown requirements, they will be insulated from a claim for monetary damages and injunctive relief. In English, they can't get sued and they don't have to do anything. Yeah.
Can I just ask some clarification question?
Yes.
So if you have a microsite or anything like that that's collecting videos or pictures, and let's say that a video has an image of Angelina Jolie and I submitted it, so me as the agency or brand with this microsite, I'm okay if I would have taken that extra step to be very
No.
specific. I'm not okay.
You're not okay. You're actively doing something, aren't you?
I'm the host though. The agency. Is the agency liable?
The only, no, if you are pressing the upload button,
Right.
You're
okay,
liable.
I'm sorry, I didn't ask the question. So I just want to understand what the liability is to
Yes.
my agency because we do these types of promotions. So we have people that will show up with a Coke logo, even though we ask in the terms of participation not to have logos or when you own all the material. So I just want to know what
you have no protection there.
Okay.
None. I mean, again, aside from all the defenses, blah, blah, blah. This only applies if you're passively displaying content. I mean, I created a web page and I pressed the enable commentary and blog and posts button.
Okay.
So, this is really funny because it's MySpace up here. I did this presentation like 2 years ago or 3 years ago. I think it was like 2 years ago. I didn't change it. No one even thinks about MySpace when we're talking about social media anymore. So we'll use MySpace here just to remember the old times. Alice puts a copy of Bob's song on her MySpace page. Right? MySpace is just MySpace. They just allow you to put stuff up on your profile. So Alice puts a copy of Bob's song on her MySpace page. Bob, searching the internet, finds his song on Alice's whatever profile page. He gets really angry. So he calls Charlie, his lawyer, and they send a letter to MySpace's designated agent. Here's my contact information, here's the name of the song, the photo, the whatever, the words that were copied, the address, the URL address of the copied song, a statement that I have a good faith belief that this material that the use of the material is not legal, blah, 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 penalty of perjury, I'm authorized to act, signature. What does MySpace have to do? They automatically take it down. MySpace then tells Alice that they've taken the song down. This gets used really inappropriately by competitors who are trying to mess with each other, but this is what's supposed to happen. Now Alice has the option of sending a counter notice to MySpace if she feels the song was taken down unfairly. Same stuff, contact information, identification, a statement that it was taken down mistakenly or not appropriately. She consents to the jurisdiction and she signs it. Then MySpace has to wait for Bob to file a lawsuit. And if he doesn't, MySpace puts the material back up. That gives the form provider, MySpace, YouTube, Facebook, Twitter, Joe Schmo's blog, protection. So long as MySpace, Twitter, whatever, follows this takedown procedure. You also have to pay a certain amount of money, fill out a designated agent form with the Copyright Office, so that you have a person who's in charge of dealing with these takedown cases. You saw that MySpace didn't do anything here, right? They just existed. And it was this little squabble between Alice and Bob, and they don't want to be in trouble for having the content on their site, so they got it to us.
I have a question.
Yes.
Does MySpace notify Bob of Alice's request?
Yes. I mean, it goes back and forth. So you're like the intermediary.
So Bob or Charlie has never gets some kind of notice that
Right.
Alice
There's an encounter
has
notice.
requested.
Now, I've seen this in my practice totally used to just mess with the other competitor. Because look, that shuts down your competitor for 14 days. It's not now all you're thinking about it in your head. Maybe I'll use this. So that's the negative, I think, to this procedure. I mean, 14 days can be ages on the internet, or it can be not a big deal depending on the kind of company you have. But
Are you saying it's a guilty till proven innocent scenario?
well, it's guilty until you do something about it. If you're so mad that you infringe my content, file a lawsuit. Otherwise, communicate with people directly. Leave us out of it.
Do you find it usually gets to that point? Because I've seen people will just say, oh, you use my photo, please take it down, and then
It gets to that point when you don't know who it is.
Oh, okay.
right? So obviously the alternative is I'm not going to go through this takedown notice procedure if I can call up the bad guy and say stop. But if you don't know, it's like that's someone in their whatever posting, then that's what you're going to have to go through. All right. So what's the overall problem? We've just identified who's not liable. The big sites. Who is liable? All of you. And if you're not following the rules of online behavior correctly, you could get into trouble. Either as the content owner and your stuff gets ripped off, or as the content sharer. We said practice safe sharing, because that's what you can get in trouble. Okay. Now, but wait a second. Everyone's encouraging me to share, right? Link to this and share this and press the whatever button that sends this out to my whole social network. But do you want me to share? Am I allowed to? Or is that copyright infringement? I don't know what I'm supposed to be doing here. Am I supposed to be so cautious that I don't ever share anything? Or whatever? Is this the new laws? So we try to come up with some scenarios where this comes up, and we'll do that. All right. So know this: just because a copyright owner invites you to share or view and discuss the work, that doesn't automatically give you the right to then repost it however you want. You've got to know, practically, is this person going to care? Because let's be honest, like your rights may be infringed, but you don't care. Or is this something you need permission to do? All right, so here's Chicago Tribune. Who's hurting the most in all this digital age?
Papers.
Publishers, right? Who's going to be really, really protective of their content?
Papers.
Papers. You asked me about news articles. They're not making any money if people don't go to their site to read the articles. So when you are bypassing the passwords to get to the content and reposting it, that's a whole slew of people who didn't visit the original place where they're supposed to get the content. And now, how is the publisher losing money, David?
We're not getting it.
There's no ads that people are looking at.
Right, there's no ads.
There's no eyeballs on these articles, and the publishers don't make money. So, tip, if you're sharing, and it's not a direct link from a publisher's site, they're the ones who are going to be litigious. So Chicago Tribune's copyright statement is the content is intended for the personal use of users of the chicagotribune.com only. While you may interact with or download a single copy of any portion of the content for your personal, non-commercial entertainment, information, or use, you may not, remember those rights we talked about? Reproduce, sell, publish, distribute, modify, display, repost, or otherwise use any portion of the content in any other way or for any other purpose. So that's pretty strict, right? And they're saying you can have one little copy on your phone and you can't send it anywhere. Now, it says you may interact, so that's the social media component. If we provide you with a little embed link that sends people back to our site to read the content, that's okay. Linking is okay because you're not reposting and taking the content outside of where it's originally intended to be viewed. So if I, on Facebook, post an article, you usually just see a little bit of it and then you click on the link to go to the real news story, right?
Now I have a question from that. Do you know if anybody's made a legal argument saying that if a video is embedded on a third-party site, they're saying, well, it's not taking people back to the video on our original channel or original
Yeah,
YouTube
and
channel.
that's where's Josh? There's a server test, right?
Right.
It's not considered infringement unless you physically own the copy and put it on your own servers. So embedding is considered like fancy linking. And so even though, again, the underlining comment for today is this stuff is so new that we don't have case law to depend on our answers. We have things we can compare it to, like linking is video embed truly the same thing as linking? We've had one case that says it is.
Yeah, that's in the Ninth Circuit.
Which is California, basically.
Right.
And tell us about it.
So essentially, it was a linking case where this website essentially had these photographs, and a search service essentially linked to these, I would say, particular thumbnails,
And basically the case, the rule in the case was that search service did not actually infringe because there were links to these particular photographs.
Isn't that a
instead of
Google
storing
image
them.
case? Is it
Right,
Google
exactly.
Images? Yeah.
Yeah, so that's the short answer, and we'll see it play itself out in more and more cases. But this is the case that says linking is okay. Ticketmaster versus Tickets.com. A hyperlink is factual information. You're just saying like, hey guys, go to this, location to read whatever is going on. And it's not considered copying.
I have a question about sharing news articles.
Yeah.
Usually when I share one, I use the headline from the article and then use a link to it. Is there anything in the case law about copying the headline? Is that fair use?
That's fair use, and that depends on the judge you get and what kind of a mood he's in when he hears your case. How much a user can post exactly is uncertain because it depends on the court's analysis of the fair use factors. Great question and good timing with slides. So you can't post a news video without permission. They have entire royalty divisions in these different networks that govern the use of their content in different places. That's how they make money, publishers. Okay, Right Haven, Michonne, go for it.
All right. Well, Right Haven is a company.
Let the
Okay,
sirens go.
Pardon the sirens. Right Haven basically is a company that contracts with, right now, I think their only client is the Las Vegas Review-Journal. They're looking to get more, but mostly on the print side of things. And basically what they do is they take all the articles and they troll. They're what is called a copyright troll. So they are trolling the internet to see if anyone is posting portions of the Review-Journal's articles. And when they find those, they then acquire the copyright from the journal, or the Review-Journal, sorry, keep messing that up. And then they file a lawsuit against the person who's posting it. Unlike a lot of places who find copyright violations who might first ask you to take it down first, they don't. They just sue you. So it's not like you get to say, okay, I have a chance to take it down. Basically, boom, you hit with a lawsuit, and now you're faced with having to get rid of it. One of the cases is Right Haven versus Democratic Underground. Democratic Underground is a forum where people can kind of discuss certain things on the liberal side of things. So it's basically a political satire site, but a lot of people share things and comment. And they posted or one of their users, I guess, posted a 5-sentence excerpt of an article from the Review-Journal in addition to a link to the full story. And Right Haven filed a lawsuit for asking for damages of $150,000. So, I mean, that's a big thing for 5 sentences. Which is the maximum that you can ask for. So, I mean, that's a lot. Right now, Democratic Underground is claiming fair use, but the claim is still pending, so we don't really know where that's going to go. And that was just as of late December.
Which means,
So.
will they be successful? Maybe not. Do they have to defend a lawsuit now? Yes, they do.
Does that cost money?
Yes, it does. Right? So, like, we are a litigious country. People sue for stupid reasons. If you're a publisher, get some insurance to cover this stuff. Yeah.
Does it ever often happen that the loser gets hit with the winner's fees in these cases? Is
Well, most of these cases do.
Okay.
But in theory, and I can't think of any off the top of my head, but yes, that does happen.
So there
Especially in case of willful infringement.
Yeah, I was going to say, in like a gray case, it's probably not going to happen.
Yeah.
It'd have to be pretty.
It's all these damages are up to the discretion of the court, of the judge. So, it could happen, but not the judge. Yeah.
If the author of the original article didn't register it, as you spoke of, and then they purchased that article, what type of rights? They lose a lot of their rights as they purchase that article, correct?
Right. Yeah.
So they're probably only going to purchase an article that is registered.
Right, and most news outlets do register on a regular basis. And a lot of what lawyers do in the context of mergers and acquisitions or submitting a film to a film festival is making sure the chain of title to the copyright is clear. Just like you buy that house, back to the house analogy, copyright law is a property right, remember intellectual property? So when you're buying that property, you need to make sure that the copyright is free and clear of all liens, just like when you buy a house. And one of the due diligence things you do is, has it been registered? Is there going to be a third party who is a co-author of that work and who's going to come out of the woodworks and claim that they own the house too? and that they're not going to let you do whatever it is you want to do with it. That's a whole other presentation. But yes, the answer is...
Is that next week?
Yeah.
If you have, let's say, a website, you've not registered it, is there really any practical reason to do that since you already screwed up, rather than simply waiting until you get involved in a lawsuit?
Well, it's $35. The filing fee is $35.
Okay.
It's pretty good insurance policy.
Okay.
And if nothing else, it allows you to write that letter with some gusto that says,
Right.
we are the registration, we own the registration to blah, 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 blah. Give us money.
And you can do that. Can you do that online and just send them a link?
You
to
can
the
do it online. Well, it's like doing your taxes.
Okay.
People who copyright things on a regular basis should learn to do it. But it's an annoying form, and it's not like you have to be a genius to figure. It's not like there's no legal thinking that goes into filling out the form. It's just a really annoying form. So if you're good at that stuff, then yes, it's $35.
And regardless of the size of the website,
Yes.
it's $35.
Yes, $35 regardless of what it is you're submitting. And there's different forms for the different things that you're submitting.
But it's $35 every 90 days for the rest of your life that it's up, right?
If you have content that you're publishing every 90 days that you want protection, yeah.
Well, right. So if you're going to do it, sort of right in one way or the other, right? In other words,
The
wouldn't
problem
you
with
say?
website, no, that's websites. The websites are a new publication date every time you're posting something. So you have to kind of make a collection and then submit that 3 months worth of stuff. It's a little, because you have to do it within 3 months of posting. So what we do is we take the entire web page as it exists on this date and submit it. So it is a little murky because new media, what is this stuff versus what was published tomorrow. So with web pages, again, we do every 3 months. But most people have a collection of photographs, or a jewelry designer has a fall collection of designs on their jewelry, and so they're filing for the fall collection. Or they care just about 2011's design, and then they file at the beginning of 2011. So it may not be $35 every 3 months if you're not posting content that needs protection every 3 months.
Daliah, quick question. What do you think of the Creative Commons licensing available on Flickr and sites like Blip TV?
So Creative Commons is a tool that allows the layperson to control their own licensing. And rather than going to an attorney every time to hash out the details of what it is and you want to license, you can go to Creative Commons and look at their little little symbols that help you decide what you want to allow others to do with your work. Creative Commons is from a copyleft philosophy as opposed to a copyright philosophy. A copyright means these are my rights and you can't have them unless you ask for permission. The copyleft theory is all that open source, open sharing mindset that says these are my rights. Please fairly share and do whatever you want with them. Just give me credit. So I don't need to go through a licensing procedure. I just want to make sure you give me credit. So you put a little attribution symbol next to your work, and you say this is a share alike so long as you give me attribution. So it's just a tool to allow you to license things more easily. Yeah.
If your website, 90% of it you don't change, and 10% you constantly change. If you register it once, pay $135, is that 90% covered forever?
Yes. So it really only, if you're a blogger and you're coming up with content all the time, then it's a little. So we talked about this. This one is also pending. This is another one, Nishan.
Yeah, this one, they actually posted the entire article. It was 33 paragraphs. This is a nonprofit organization that looks to help immigrants and refugees. So they're not trying to make money. They're an organization that's trying to help people out. And they posted an article from the Review Journal about Las Vegas police and immigrants. And so they were just posting it as some information, to do that. But it is the entire thing, so it's not just a little excerpt. So the fair use thing gets kind of murky. However, the most recent things, a federal judge was kind of skeptical about whether that was really harming them. I believe the exact quote was, "Do you really think they're making any dough on this?" So it really kind of depends on what judge you get, whether you're going to get a fair use. And so it's really kind of a crapshoot. You can hope that it's going to work, but if you get a really cranky, copyright protecting kind of judge, not necessarily going to work for you. But, they kind of drew lucky on this. They might be able to, it might work for them.
So
it just really depends.
Two sentences versus the whole article and different outcomes. People, sorry, you're not going to walk away from today's seminar saying, you can only post 4 sentences of any article and then be okay. There is no safe number. There's not the 10% rule. That used to be the other thing. If I only use 10% of something, I'm okay. You all know what fair use is now, and that's not the case. Okay. Another one.
The last one, they posted 8 sentences in a 30-sentence thing, and it was dismissed as fair use. So you got 8 sentences, 33 paragraphs, 5 lines and a link. You never really know.
All right. How much time do we have? All right.
Daliah,
Yes.
is it common to ask for you to be able to post someone's article?
Yeah.
And so they'll
People,
give you.
I have a posting on SlideShare, my social media PowerPoint is like 6,000 views. And I decided I want to know who's using it, so I unclicked the embed thing. So I get emails on a regular basis. I'm a college teacher. I'd like to use your social media presentation. Can I? Yes, you can. Here's my, and then I control.
Here's my what?
Here's my PowerPoint.
So, but I mean, what type of approval do you have to give in writing?
Writing.
Okay.
Good idea to get in writing.
So
An email can
you'll
help
just
too.
email approval.
Yeah, it depends how formal you want to be, but you want something that says, if you go to a lawyer, I hereby grant you the unlimited or like the limited exclusive right, all those little words to do all these things with it. But I don't care if someone uses it I'm already putting it out for consumption anyway. So if I really was worried about it, I wouldn't be posting it up anyway. That's why practically speaking, the law is this. The law is this technically. Practically, or is the person you're sharing content from going to care?
Email approval's acceptable then?
Yeah, it's not ideal, but it's acceptable.
Can I speak to that just as a publisher?
Yeah.
Because we get requests all the time for user content. And that's exactly, we're fine with that. What we'll do, we do our own trolling, we're doing research going out there, we find their name, we see anybody's posting our stuff. So usually we won't, typically it's a lawyer in town who's mentioned in an article who wants to put it up on their website. So and we do have a paywall, so they can't get through to our content without being a subscriber. But we also like publicity too. So what we'll do is we'll contact the lawyer and say, okay, buddy, please, you need to have permission to do that. And then, we will get that in writing for the request of it. So it's a common practice. But I'm glad you brought that up because I was going to say the same thing. We get into law and lawyers, then things get escalated to a different phase. And I know you need to be employed. Certainly.
No, I'd rather be employed on something that uses my brain.
Right, exactly. That's worthwhile. But so many of these things can be.
Right, and that's why Creative Commons exists. That's why if you've been to any of my other lectures, I always say you should take control of your own copyright registrations. It's nothing that you can't figure out how to do yourself.
With the copy left, as you say, I guess the issue is, does it have any source of being legally binding, or is it just a notice? Just like you can say, okay, I don't want this for commercial use, but you can use it, for other purposes too.
Well, Grant, great question. Copy left concept is, again, that whole open source concept, and it usually applies in the context of code, open source software code, but it does apply, in the context of copyrightable photos, not copyrightable internet code, not internet code, software code. The law says yes, they're very enforceable. Now, the issue of damages gets a little bit more murky, and there is a dichotomy between a breach of contract and a copyright infringement when there's money involved. The designers in the house will come to me and they'll say, I did this logo for someone, I gave them rights, but they didn't pay me. I want to sue them for infringement because I own the work. Well, yeah, kind of. You can't sue for copyright infringement there because you made the work for them for that purpose. There is a minimum, an implied license for them to use it for the purpose that you contracted for. So you have to go into court on a breach of contract case, not on a copyright case. In a copy left scenario, you have to say, was it a condition or was it a permission? It's like, it's wordsmanship. And at the end of the day, if you weren't going to make money on it anyway, what are your damages?
Sounds like it'd just be problematic for you because it's an implied licensing, and then it goes through the interpretation of how it's used.
Yes, no. I mean, you will win. If I said, you can use my stuff for free, you just have to give me credit, and you use my stuff and you don't give me credit, I can sue you if I've registered my work and get a minimum of $750 to $150,000 in statutory damages. Let's say I didn't register it in time, and I sue you, and you didn't give me credit. Where are my damages?
So you're saying it's added insurance on top of you registered the copyright because this person was obviously aware if that's where they got the content.
Yeah, and again, this open source and all this is another presentation. So talk to your lawyer to see what your specific situation entails. All right. What else? I have a lot more. I'm gonna try to not repeat myself. All right. I have museum exhibits, but think of this as what you can and can't do when you're on vacation, right? People come back, they take pictures of the museum they went to, or they take pictures in a private location that they were in. Can they do that? What do you guys think? Well, don't read. Most of the time, you see these signs that say no pictures, right? No flash photography. Do you think that's to protect the work, or to protect the business interests of the museum?
Does it matter?
Well, let's read it.
Yeah.
Please refrain from any photography of loan and temporary exhibitions. You're welcome to take photographs of the permanent collection taken in an existing light on condition that they are for personal, non-distributional, non-commercial use. Flashes, tripods, and video cameras are prohibited. Why? You ever notice when you leave like a museum that you go through the gift shop? You ever notice there's a lot of tchotchkes you can buy with photos and things of the collections that are in the museum? So it's really a business interest, and what they have, Art Institute, for example, has an entire legal department devoted to licensing of their collections. So if I go in there and I start taking photos and make my own whatever, I've now cut into this private institution's ability, or even public institutions, of copyrights to the work. So you're going to have a whole slew of issues, including, copyright. We have an example. Oh, there is an exception, kind of. Ever heard of the public domain? What is that? That's the public domain. What does that mean?
Where copyrights expired.
Exactly. So if something's really, really, really old, and I'm talking prehistoric, because you may not know if it's 100 years old, it may still have some sort of copyright protection somehow, somewhere. But if you're talking about like the Mona Lisa, which I think is pretty old at this point, I don't know, how old is that? It goes back.
Da Vinci time. So
Yeah, it goes back
500 years.
a little bit. So if I want to then take, this is a real client that came to my office and said, I'm making this collage, and it was some other artist that was old, but we'll use Mona Lisa because that's what I'm looking for. I want to use this image of the Mona Lisa in my photograph. It's a collage, it's a screen print, and I'm taking this postcard of the Mona Lisa and I'm incorporating it into my painting. Is that good? Is that okay? It's public domain. Is that okay?
But it's a photo of the Mona Lisa taken by a
You are like the A student right now. Yeah. Right. Did you hear that?
No.
So the subject matter may be really old. The Mona Lisa is really old. But the photograph of the Mona Lisa is not old. The photograph is owned by the Art Institute or whoever took that photograph to sell you the postcard. So you may go and take your own picture of the Mona Lisa and incorporate it into your work, but you may not take a picture of something really old taken by someone else and incorporate it into your work.
How can you know?
I'm sorry?
How can you know?
Well, did you take the photo on the
Well,
postcard?
Well, who else would know?
Who would
right?
know?
Who would know?
This was my photo of the Mona
There's
Lisa.
millions of photos out there of Mona Lisa.
But
Who's to say that's mine?
you didn't take that photo. That photo is owned by someone who took the photo.
You know,
He was
you
saying,
can-
how can they prove they were the photographer?
Oh, well, then that goes into the whole fact-based scenario. That where did you take it from? Where did you find this photo? You can find you. In fact, I'll skip to the last part, which is the most exciting part, and then we'll go backwards. I asked Josh to find. Remember, digital age, right? Everything is geotagged, mapped, and images and faces are coded. And if it doesn't exist, it'll exist tomorrow. There's ways for digital content management, right? What's that word? Digital rights management. There's tools out there that allow rights owners, whether it's music or images or whatever, to find out if you've used their stuff in a different location. And all right, professional photos. You asked me about a photographer. You don't own the pictures you pay for. People always say, I paid the photographer, I paid the designer, I paid them for this stuff. Doesn't it belong to me? The answer is no. They're under the work for hire doctrine. The only time you own the work automatically is if the person is your W-2 employee, So if I hired a person to do work for me, then automatically that person's work belongs to the employer. If I hire a freelancer, the person who owns the work is the freelancer. Unless I ask in a written document for them and I say, you're being hired pursuant to a work made for hire. You're being commissioned to create this work pursuant to work made for hire, and if for whatever legal reason it doesn't count as whatever that statute defines as a work for hire, you hereby assign, remember what assign means versus license? You assign to me the rights to whatever it is I've hired you to do. If you don't have that piece of paper, your rights are only the implied license to use the work. Meaning, I hired you to take pictures for my website. If I then take those pictures and put it in a magazine article or a magazine ad, the photographer could theoretically stop me. You didn't pay me for using it beyond just your website. When we made the deal, you just said you'd use it on your webpage. So it's really, really important to get a work for hire agreement if you're hiring a freelancer for anything you're doing.
What about background, people that are in the background of, I take a picture of you, there's somebody in the background?
You are talking about a right of publicity issue, and that's when model releases come into play. It's not a copyright issue, it's a personal right of how you can use my image issue. And the case, I'm just going to skip the professional photo stuff. So basically the point is you can't use if your wedding photos are given to you by a photographer, you can then upload your wedding photos on Facebook if you haven't gotten permission. You can link to them or tell people you can buy the wedding photos here, but you do not own your photos of your wedding unless you pay for them.
The question I was asking was, what about the people that are standing?
I know. I'm backtracking, but yes, that will cover. Get that. We covered, do you own your own social content? This is what you were asking at the beginning. I promise, right publicity.
Thank you, yes, no problem.
Okay, this, because it's on here and I'll forget. Facebook, you own all of the content information you post on Facebook. You give us a non-exclusive, transferable, sub-licensable, royalty-free, worldwide license. We can do whatever we want. So practically we have all of the same rights that you do as the owner, short of we don't stop you from using it however you want to. Same thing. Okay, porn and other musings. You want to get Adam?
Yeah, sure.
All right, right of publicity is the second bullet point. And what that means is every person, right of publicity is a state-based right. It's a state-based thing. Copyright law is federal. Regardless of where you live in the country, it's going to be the same law. State right of publicity laws differ. In Illinois, you may have the ability, you may get certain rights versus in like New York where you get different rights. Right of publicity essentially means that you are the only person who controls how your image is used for commercial purpose. If I'm walking in the street and someone takes a picture of me and does a news article about it, probably don't have a claim. They're not making money off my face. If, on the other hand, you're talking about porn soon. If, on the other hand, I take a picture of you in the street and I start selling bottles of water with your image right down the middle, you didn't get, it's like endorsement, right? That's why you put your kid in baby modeling, so you can make money off his face or her face. So if someone takes a picture of you for any purpose, then they need a model